So the other area that I really want to emphasize to you, and really, I want to sing you guys praises because you're one of the leaders in terms of bringing this forward. So therefore, I'm going to talk about how it's important for a doc to get involved as early as they can in this process. Like on first notification, realize you're in deep water and you're going to get swept out to sea in a riptide if you don't do something about it.
So again, my name is Attorney Juan Santos. I'm based here at the Miami office. I have a master's in health law from Loyola University of Chicago, which Mr. Chapman also has the same master's that I do, and Ron the second also has the same master from the same school, which is pretty great. What I do basically, I'll say that I do 20% licensing, defend doctors and any healthcare provider before their board, their professional board. I do 30% probably of criminal because my client get to me. There's some big laws that we can talk about later, maybe at another podcast, called the anti-kickback statute, Stark law, HIPAA, and those, specifically the anti-kickback statute, has criminal consequences. So we basically do a lot of Medicare fraud, and we're in Florida, so we're the capital or number one in healthcare fraud. And I do compliance, which I really like. And I think, doctor, with what you're telling me that you want to help physicians through this process, in my experience, physicians don't want to break the law. Physician, what happens is that they're so involved in treating patient and providing care. And basically that's what they were taught to do, right? To provide care, to do medicine. Because of CMS, Medicare, Medicaid, and private insurance, they spend more 50, 60% in administrative work. And they didn't go to law school, right? So I think what you're doing it's great because you want to teach physicians on prevention instead of enforcement.
Well, that's exactly it. That's exactly right. Let me just offer a little bit of background here. And that is, so my name's Kernan Mannion, and I'm the executive director of CPR, the Center for Physician Rights. And I began a study group about 10 years ago because of my own involvement with the board and the physician health program. And it's pretty likely it was in the context of my blowing the whistle at a major healthcare facility, a military facility. Bottom line here is that I went through this dark side tunnel and I realized, oh my gosh, there's some very powerful forces here. And as a physician, I could not get over the power of it. I could not get over how complicated things got so quickly, how expensive things got, how prolonged they got. And the more I talked with physicians around the country trying to reach out, going like, is this possible? I mean, how is it possible that I thought I had rights, and I thought I had the right to defend myself. And I thought it would be just easy enough to kind of come in and say, hey guys, this is what I did, and this is me. I'm not off balance. And yet a cascade of things happens very quickly. And so where I'm coming from on this, and I'm delighted to be your guest here to take this time today to talk about and explore with you and hear from you some of the concerns you may have about physicians and what they've been through. Because now I alone have spoken with several hundred detailed interviews with physicians over these years, and my colleagues together have probably spoken with over 500 physicians around the country, who are grappling with these issues. And the domain really that we're predominantly focusing on, just so that you know, is not the explicit wrongdoing where you actually have done something wrong and you were going to be disciplined by a board and that's basically factually established. That's not what we're really looking at. We're looking at predominantly those issues where somebody has not done something wrong. And now they're being pulled into a system on an alleged complaint, often an anonymous complaint, and then they're being pulled into an allegation of impairment or disability, and then going to the PHP system. So that's where I'm coming from. And again, I'm just so enthused about the possibilities that exist for our conversation today. Thank you.
So perfect. When we talked about some type of impairment here in Florida, for physicians specifically, and I'm going to make a distinction, PRN, which is the Professional Research Network, is a not-for-profit entity which has a contract with the Department of Health, basically a monopoly, where through that contract, any physician, or to tell you the truth, PRN handles any healthcare provider that is licensed by the Department of Health or business professional regulations like veterinarians. And then nurses have a separate entity called IPN. That entity, IPN, this is extremely important. IPN is a for-profit entity. PRN is a not-for-profit entity. Now, when I learned in law school is that the only difference between a not-for-profit and a for-profit is that one pays dividends to its shareholders and the other one pays huge salaries to basically management at the end of the day.
Is the nonprofit one also a 501c3 educational public charity?
That is correct.
Yes.
Is correct.
Yeah. Well, and yeah.
So what happens is that when a physician, and you are correct, any person can contact the Department of Health or the board anonymously and file a complaint. I've had cases where ex-wives going through divorce or people are getting divorced where the ex-wife calls the DEA, not only the licensing agent, they call the DEA saying that the doctor is overprescribing, they call the board. Then an investigation starts, right? Now, how the process goes is that you receive a letter and stating, hey, listen, these are the allegations that X person made, or it was anonymous. We need to corroborate that that is in fact true, right? Or that there's evidence for that. Immediately, you have to contact an attorney and we have to file a response within 45 days. That response is extremely important. If we're talking about impairment and allegations of alleged impairment, you want to have letters of recommendation from other colleagues. You want to have drug tests, urine, blood. If you have a hair drug test, that would probably seal the case. You want to provide any other type of information and or affidavits or sworn statement from other people that deal with you in a daily basis, that basically performance evaluations on your job, all of that, so that we can dismiss the case right then and there. Now, the Department of Health, they have a mechanism, and I've researched this, and the appeals court side more with the government because of the welfare. They're looking for the welfare of the people of Florida, but there is what is called an order to compel examination. And that basically is an order from the Surgeon General and the Department of Health sending to a physician saying, listen, on April 1st, you're going to go to this doctor that they will select for you, right? In reality, legally, I should have the chance to get the healthcare from whoever I want, right? But what they do, and I'll explain that a little bit later, you get that order to compel examination, and that doctor is approved by the Department of Health and PRN to issue that evaluation. And this is where the conflict of interest starts with PRN. What happens? PRN doesn't employ the physicians. They don't employ them. But what happens is they're a monitoring company that they monitor for, they conduct the drug test and they do meetings and weekly meetings and monthly meetings, etc. But what happens is that they came up with this system, which I think is extremely flawed, where let's say, doctor, let's say that you graduated from Harvard, addiction specialist, PhD from Yale in addiction, etc. And you are not certified by PRN and the department to issue this type of evaluation, they won't take them into account. So what happens? The Department of Health and PRN, they basically come up with this program where they will certify the doctors, and those doctors are the only ones that can issue an evaluation that will be taken into consideration by the judge and or in the informal hearing. What happens? This is where the conflict of interest starts.
Oh, of course, it's a rigged deal. They can select their own panel of evaluators that are going to sway their way.
Exactly.
This is basically rigging the whole evaluation. This is like judge rigging, jury rigging, except it exists in the medical forensic arena.
That is correct. That is correct. And it gets worse because I started dealing with PRN and IPN when I started in Chapman. In 5 years, I haven't had one client. Doesn't matter if it's a nurse, physician, any healthcare provider that have gone to IPN or a PRN evaluator, I haven't had one that they stated that they don't need any monitoring. I have people that have tested negative for all drugs. I don't know, they always find they have some type of anxiety issue or that they need some type of treatment, but I haven't had one. And I'll give you an example.
So you're saying you haven't had one that has been mandated for monitoring, or you haven't had one that has not been mandated for monitoring?
I haven't had one that has not been mandated.
So in other words, it's a conventional process for them, customary. Everybody
automatic.
Right.
So the only case that I had, it was with I had a case with a veterinarian, And the doctor was getting through a divorce. He divorced his wife, married her again, and he was divorcing again. Wife called the DEA, wife called the Board of Professional Regulations, and basically stated that he was, using his own drugs and prescribing to himself. The doctor said, hey, listen, that's bull. And he said, one, I will leave the profession before I go into PRN. We went to an informal hearing, and we put PRN on the spot, and they accepted, Neil Tomaszewski and the people from PRN accepted that, and I think it's 100%, but they said that 95% of the people that contact them end up in a monitoring program or in an outpatient or inpatient facility. Yeah. Now, the conflict of interest gets worse because they select what facilities you can go to and are approved by them if you're going to do outpatient and inpatient, and they select the doctors. Now, we had a doctor that we found that was certified by the department, because they won't tell you what doctors are certified. They will tell the physician, you have these three options. And we had a doctor that was certified but was working with defense attorneys, and they took her certification away because basically we won some cases with her.
Of course. Right.
So it's extremely, you want to try to avoid PRN. Many of my clients think that, hey, listen, I have no problem, so I just go in the program and that's it. If you go in the program,
I can't agree with you. I can't agree with you more in terms of the flawed process. And that's one of the things that we've been looking at CPR, and looking at the infrastructure of this entire system, not only in Florida, but across the country. And there's similar patterns. You mentioned the Medical Practice Act. The Medical Practice Act that's based upon FSMB's Model Medical Practice Act, the Federation of State Medical Boards Practice Act. And every Medical Practice Act has a reference to it, both a section on discipline and a section on impaired physicians. And then what we found is that the section on impaired physicians then refers to some sort of an agreement for assessment. And the board then has these emergency powers to order an assessment. And now the understanding has been that you can order an emergency assessment if there's a real direct threat to the public. And what we found, what we believe we're seeing, is that what's happening is that there really isn't a direct threat to the public. But what's happening is the physician is being charged as though he is a public menace, a public threat. And from the time of charge onwards, the physician's career is destroyed from the time onwards. And this is unacceptable. And so over the period, the last decade, really studying these issues and understanding the interface amongst the various administrative laws, civil laws, state and federal laws. For most physicians, by the way, most physicians, I would have never had this understanding had I not been chiseling away at it for the past 10 years. I admire you guys greatly for being able to sort through just the judicial system itself. It's really so vexing. And that's why physicians are at a loss, is that they've got to find a lawyer who really understands the system and says, okay, this part of it is the administrative system within this state structure, and here's how we're going to go about this. And then also, most importantly, is a lawyer who's willing to stand up for the physician and go up against the powers that be, not simply cater to them. And so, and what I'm seeing here is that physicians are, they pick up the phone and call their neighborhood lawyer, who did their will, and says, can you represent me in this thing? And guess what? He says, well, I'll see what I can do. And time squanders, and he writes a few letters and gets into a struggle with the board, overpowered. And a year goes by, and $20,000 of retainer goes by. Before you know it, nothing's happened, and the doc's out of work. So yeah, so I really want to emphasize that what you're saying is crucial. And I think, and tell me if I'm wrong here, at the very first indication of wins that are occurring with regard to any administrative entity, get professional help, legal help.
100%. And we deal with many criminal attorneys, that they do DUI, drugs, or whatever the case may be. And they contact us and they say, listen, I want to handle the criminal matter, but I don't know anything about the administrative matter and the licensing side of things. And that's extremely important, because if you have a criminal case, there is some specific status in the Medical Practice Act that if you plead to them, you could get banned of the practice of medicine for 5, 10, or 15 years. So something like if you were accused with fraud in getting controlled substances,
right,
that fraud in getting controlled substances will ban you from practice for 10 years. But if you can get a grand theft that doesn't include fraud then that's a loophole. And then, so it's extremely important to know those details so that the
Right.
deal that the criminal attorney is going to make
Right.
doesn't affect your profession.
Yes.
Another important thing that you mentioned, the problem becomes when we're dealing with impairment, right? The problem becomes that in the law, and this is chapter 456, Health Profession Regulations, the government and the department and Congress, and Florida at least, they give you an incentive that if it's the first time that you're in trouble and you enroll in PRN or IPN for that matter, they will dismiss the case. So many people say, hey, listen, all right, so instead of telling my boss or telling my supervisor, let me put this under the rug, I'll go through the program. But the program, it's kind of like a military regime. Like, you have to get drug tested. They can talk to your employer, no alcohol, not even a sip of wine, when you really don't need that. So what they're doing, they're overusing basically that power that they have, and basically sending people to
Well,
PRN.
that's the question, is really,
need.
do they have that power? And I think it's a question I want to challenge you with here. Is I just did a webinar last night with my colleague who has researched PHPs like nobody's business. And we also looked at the use of inappropriate drug testing, alcohol biomarker drug testing, the ETG, the ETS, and the PEth test. Turns out that these are not FDA approved. They're laboratory developed tests. Most physicians and lawyers don't know this. And so what's happening is that what we have is an entire artifice that's been constructed that seems to empower entities like PRN, which is, a standard PHP, but goes under that, whatever it stands for, Professional Renewal Network or Physicians Renewal Network or something like that. And as we examine this more closely, we say, well, now, wait a minute. How'd you get this power here? And there are a number of things. I'm enthused to pass this by you. One of my colleagues out in the West has discovered that each of the PHPs around the country seems to have an exclusive contract with the state. And you go, well, that's kind of curious. How'd you get that exclusive contract? And how is it that you're all following the same abstinence model? Okay. And so he then began challenging that. Another aspect that we've been looking at is ADA. And that is, as soon as somebody is regarded as disabled, they're covered under the ADA. Now, you and I know this, but for those who may be listening here, I just want to clarify that I was alleging that, hey, wait a minute, guys, I'm not disabled. Okay, I'm being sent to the PHP because I'm allegedly mentally ill because I had gone to the police to express concerns about my safety, right? In the context of being a whistleblower. And so I then am labeled with this. And so I'm arguing, hey guys, I'm not disabled. And I'm trying to figure out what laws might pertain. And out of the blue, one of the people on CPR's CPR's mailing list, calls me and says, hey, Kernan, why aren't you guys hiring somebody like a disability attorney to help you with this? And I said, why would I hire a disability attorney to argue my case when I'm saying I'm not disabled? He says, you don't have to be disabled to be covered under the ADA. You are covered under the ADA when you are regarded as disabled. Now, this opened up a whole new avenue, right? And so what I, one of the things that I really want to challenge you on, I want to hear your response, and that is, why are we giving these people this power to do these things when it may not be legitimate power to begin with? If they're arguing that they're a 501c3 educational nonprofit public charity, right? And they're conducting diagnostic evaluations that are the equivalent of forensic psychiatric evaluation, why is that not a medical procedure?
So the problem, and I've been trying to figure it out for years. So the problem becomes that the person that's doing the diagnostic test is an independent contractor, right? So what they do, the conflict of interest, what PRN says, hey, listen, I have no control of what the doctor is saying. He's not employed by PRN. We send you to him because he's certified by the department, and we trust him because he's certified by us. And then because they're not employed, they only do the monitoring, and they refer to the PHP program and or the inpatient treatment program. The other issue that happens is that at least you have two options when you have this type of case, right? You want to try to dismiss it outright so it doesn't become public. And you said something extremely important. When you have a case, and you know this, if you have a case by the board and the Department of Health, in your record that it's public, that basically is like a felony in your record. Contracts with Medicare, hospital privileges in the contract, hey, listen, you cannot have it.
Right.
DEA, if it has to do with impairment, they can come in and try to take your DEA registration. Private insurance, CMS, OIG. So it's a domino effect, right?
Well, and National Practitioner Data Bank too. Let's not.
National Data Bank.
That's kind of like being listed on the sex registry, the sex offender registry.
That is correct. For being a doctor, that is correct.
Right.
That is correct.
Yeah.
So you have to try to figure it out a way where either you can dismiss it outright or just be in contact with the prosecutor of the Department of Health already. Right. Hey, what do you want to do in this case? What are you looking at? You know, review the evidence, send a letter with all the evidence. Hey, listen, you cannot prove the case. Let's dismiss it. And they came up with what is called a letter of guidance. So now the department, if they're on the fence and they don't know if they want to recommend a formal complaint or they want to dismiss it, now they will dismiss it. It will be confidential, but they will issue a letter of guidance that will be on the Department of Health confidential record. If you do something exactly the same as what is mentioned in the letter of guidance, they can use it against you in another case. But it's confidential and nobody knows about it, which is a little bit better. Now, then you have to make a decision. Listen, am I going to fight the case and go to a formal hearing? And this is the difference between going into a formal hearing and an informal hearing. In the informal hearing, you don't dispute the allegations as they're stated in the complaint, but you can provide mitigating factors, and there's 13 mitigating factors that you can provide to the board and the panel, so that basically the penalty, you know, they can be the least penalty possible.
No, wait, so are you telling me that in the informal hearing, you're not able to challenge the fundamental allegation?
That is correct. So
how is that possible?
Because what happens is once you receive the complaint, you get what is called an election of rights form. That election of rights form gives you two options. It says, I do dispute or I do not dispute. If you dispute the allegations, then the case gets transferred to DOA. DOA in Florida is the Division of Administrative Hearings. It's an agency of judges that they basically get all of the cases from all of the administrative agencies of Florida.
So that's like a contested case hearing.
That would be kind of like a civil case. We can cross-examine a witness, depositions. It will be kind of like a civil.
So wouldn't it be in everybody's advantage to file a contested case process right at the outset?
But you have to provide evidence to dispute the allegations. For example, I get a client that received a letter because he was positive in a pre-employment drug test. I have two options, right? Either I find a change of custody of the test, that the test was done incorrectly, or that it was a false positive. If I cannot show that, then I got to go to an informal and probably send him to PRN or another doctor to say that he's not impaired.
Well, how's this? Consider this for a moment. Imagine this, that tests that are being used to assess physicians, this is physicians, and I suspect it's all healthcare providers, but tests that are being used, the urine test and the drug tests that are being used, not only are not approved by the FDA, not only are they laboratory developed tests, they were never designed for use in the forensic environment. And SAMHSA, the Substance Mental Health Service Administration, issued two advisories, 2006 and 2012, against their use in the forensic environment. And get this, the developer of the test themselves has said, we really don't know what the normative data is. So what's happening is we have experiments. So now, therefore, if I'm understanding you correctly, then what you're suggesting is that if one could show that the allegation is flawed based upon false test results, then one could go to a contested case hearing, or whatever we're calling it. Well, then, my gosh, it seems to me, if that's being customarily used by PRN, then first of all, it seems to me, a non-lawyer, by the way, that this is an avenue to challenge every allegation, and not only that, to cause a retroactive examination of all of those that have been done in this way, but then secondly, to then also involve the Department of Health and to say, are you aware that they're using a test that is an experimental test, that it does not have grounding and has been advised against? And then to ask the Department of Health to investigate, what right do you have to do this? Because what they're doing then is they're then enforcing this, they are enforcing an approach to an understanding of substance use that is not in the mainstream. It is not in the mainstream in terms of how we understand the use of substances. Physicians are being accused of impairment as though they were the town drunk, simply because they got high at a party, okay, or whatever, and anonymous allegations are being made. So therefore, what's happening is that from the time of accusation, and the power of this is so profound, from the power of from the initiation of allegation, your career is destroyed, your community is destroyed, your family is destroyed, and then you're being sent to a rigged network. This is against medical principles. And so what I'm trying to understand is, why is it that the legal community is not arguing on the basis of this is, yes, okay, I understand your laws are written this way, but it is in violation of federal law, for example, ADA, that you can't mandate how someone is going to have their evaluation. This just doesn't flow, and it's against medical principles to rig your selected people.
All right, so I agree with you. Now remember that we're talking, when we're talking about the test, we're talking about the PETH test, the alcohol test.
That's right.
And in every response that I draft regarding possible impairment for alcohol, I have the testimony of an IPN, a person that was IPA management, saying that it's not reliable. I got the SAMHSA notification of 2012. All of that is in my letter. Now what happens is that I'll say 5% of the cases that come to me, it's regarding alcohol. Usually it's a test that he tested positive for another substance and all of that. But when it comes to alcohol, I agree with you. Take it to a formal hearing, go to DOA and fight it all the way. Even mouthwash in the morning can trigger
even hand cleanser. Even
Correct.
hand cleanser can do it. And now, how many healthcare workers use hand cleanser, alcohol-based hand cleanser? It's impossible to avoid, right? Okay. So therefore, you are automatically going to show positive, and that's going to show that, oh my gosh, you relapsed, and therefore you're going to be punished for life. We're going to put the shackles on you.
No. And what happens is that you relapse, and you know what they do? They really don't punish you. What they do is they'll extend your contract.
That's
so
right.
So they want to keep you in the system. So,
that's right.
And I have a client that I'm fighting that right now is a false positive for alcohol, a medical student, and we have her drug test, her drug and alcohol test that tested negative. He was being, give me 1 second.
Yeah.
So I agree with you 100% that the system, the problem is, you were saying about suing and the federal government and ADA. The only way to come after them is it needs to be through a class action lawsuit, right? Because what happens is that doctors basically have the power under their medical license to basically provide an evaluation, right? And it's extremely hard if it's not through a class action to prove that the system is rigged, right? You need 50 people, 100 people that the same thing happened. Because again, you have PRN is a not-for-profit company. They don't employ the doctors. Now, you need to link and you need to prove that those doctors that although not being paid, all of them, we have to get discovery on the percentage of each of those doctors that have sent the patients, probably 99.9% of their patients to PRN, right? Then you would have to prove people that were doctors that they didn't send them to PRN and they got their certification taken away. So they know how to protect themselves. It's been going on since the 80s, right? This program. So we have to attack them in a class action, which takes time. Lately, with IPN and PRN, I'm getting frustrated because basically, if I go to an informal hearing with the board, basically they will take PRN and IPN side. So basically what I do now, I just go straight to the formal hearing because the board are just going to side with them also to protect their behinds, right? Because let's say, for example, the panel member of the board is there and they review the evidence and they saw that you tested positive. I tested positive for alcohol or weed. Let's say weed. You got high on a Saturday, right? You were not working, out of work, whatever. And what the panel member sees in the evidence is that, hey, he was sent to a doctor and the doctor says that he needs treatment. Now that panel member, although I tell them every time, but that panel member doesn't know the entire story. He just sees a medical evaluation.
No,
so if we
it
get
looks
a
like a
second medical opinion,
it looks like a legitimate medical evaluation.
It looks legitimate.
Looks like it, but it's not. It is not. It does not follow the ethical guidelines of a true fitness for duty evaluation. It is a rigged deal. Yeah. And one of my colleagues, I'm happy to say, another forensic psychiatrist is working on a code of ethics for fitness for duty evaluations.
Nice.
And so therefore, we're then going to challenge what's going down as quote unquote fitness for duty evaluations. These are not. They're rigged deals. And everybody knows, that a court of law, a hearing where you have an adversarial relationship in calling expert witnesses, this is not really a search for truth. I mean, we kind of have to get beyond the fact that the truth is going to come out in a hearing. What we have is a rigged deal. Okay. And unfortunately, the powers that, as I see it, okay, the powers that be have all the cards, and they can keep playing card after card after card. Select your own consultants, including your own evaluators, who are going to give you the result that you want, because from their past years they're going to give you the result you want. Now, this is not fair. Right.
No, and it gets worse, because then they tell
I know it gets worse.
It gets worse because then they tell you, get a second medical opinion, but you can only get a second medical opinion out of these two doctors.
Well, that's exactly
right.
So
it's
that's crazy.
Pointless. We haven't even talked that everything is cash. They don't take insurance.
Yes. Well.
They don't take insurance for the partial hospitalization program, for the inpatient treatment, and they always say that they're trying to assist the client and the patient, which is a bunch of baloney also.
Yes,
so the system, I agree with you. Yes. And I fight with the boards, and I deal with PRN and IPN. I go to probably all the hearings. The next hearing is going to be in April the 2nd. It's going to be in Miami. Just to let you know, at the Board of Nursing in Deerfield. But I go to all the boards and I deal with them, and it's something that I'm proud and happy that you're taking a look at it, that you found out what is going on. Mr. Chapman and I and our firm have been saying this. He's been interviewed for people, for NBC News Investigates and all of that, because, at the end of the day, the system is rigged and the providers are the ones paying for it.
That's right. And I think, sometimes we have to try things outside of the mainstream of law, and that is through the public and through educating the physician community. And I think what's happened is that, here's the amazing thing. Tell me if this is your experience. And that is, when I explain the situation to most physicians have no exposure to the board of the PHP. They're just kind of like, the board is just kind of like a nuisance bureaucracy, and the PHP, they don't even know what it means. They don't know, or PRN, they don't even know what it means. So it's kind of like out of their camp of awareness. So this affects less than 10, maybe even less than 5% of practicing physicians. But those who are affected by it, once they're pulled into it, they're swept out. I've described it as walking innocently along the beach, right? And you guys are down in Miami, innocently walking along the beach and stepping in a little tidal pool that you look pretty innocent, and then suddenly you're swept out to sea in a riptide, right? Wow. And what happens to anybody who's swept out in a riptide, the only thing you're trying to do is survive. You can't even believe what happened to you. You're going to drown. And then you make the second mistake, and that is trying to swim back to shore against the tide, against the riptide. And then you're fighting. So our task, I think, is to educate the physician community and, by the way, the legal community about the complexities of this system, so that we can affect change. We're not trying to get a bunch of drunks and drug addicts simply out of jail, right? That's not what this is about. This is about protecting rights and say, okay, if you have an addiction problem or substance abuse problem, a legitimate one, you have a right to treatment. But if you're being falsely accused of that, and the diagnostic criteria are being bent by a rigged evaluator pool who have a vested interest in a certain treatment model and a certain treatment system, and who may even have financial interest in those, then we have to address that, because this is an assault on not only law, it's an assault on civil rights, it's an assault on the ethics of medicine itself. And we have physicians who are committing suicide as a result of this.
100%. I agree with you completely. I'll say my clients, maybe when I'm talking about licensing and physicians, probably 80% of my clients, or 90%, that get a letter of some type of impairment or diversion, they don't need PRN. I talk with them, they're working every day. I'm talking with them, they're doing surgery. They're doing, one basically went to a cruise. It was his 20th reunion.
It's inappropriate treatment. It's inappropriate treatment. It's basically, it's punitive and it's opportunistic. It's predatory is what it is.
Exactly. So it's something that we fight every day. But the first thing that you need to do, and this is the most important thing for your listeners, anybody that tells you, either because, they're doing an investigation in the hospital, somebody stole drugs, and you take, anybody that tells you go and report to PRN, you need to contact a healthcare attorney. Many times.
Immediately.
Yeah, there is many times, and this happens to many of my clients. They don't know better. They contact PRN, but they already contact them, and then they start reading. But the PRN already knows about them, and then they start reading, and then they call me, and basically we have a problem because they're already on the radar. So what PRN does is that if you don't call them back, they will issue a letter to the Department of Health closing the case and saying that you didn't comply. And the only thing that he just was pick up the phone and call for information. They take all, and then they pressure you. They send you 100 emails, phone calls. Hey, listen, your license is going to be screwed. They put all this type of pressure on you that people just basically say, hey, what the hell? I'm going to have to go
that's
in.
right. That's right. And attorneys who are less informed than you, who are naive, say, oh, why don't you just go ahead with the program? And that's a death sentence. It's a death sentence. And so physicians are getting bad advice about, oh yeah, why don't you just go for the 4-day evaluation? You know, if there's nothing wrong with you, then everything's fine, right? And what they don't understand is that there is going to be something wrong with you.
Well, out of 100 cases, 100% of my clients always they find something. Right. And the problem is that sometimes it's not that easy because the system is conspiring against the provider. I'll give you an example. Under the Medical Practice Act and the Chapter 456, if a person in a hospital, your boss, a supervisor, thinks that there is some type of impairment or some violation, they have to report you. So what they do, thinking, hey, listen, I want to be nice, and I don't want to report you to the Department of Health, but to cover their behind, they tell them, listen, just go to PRN. We'll keep it, you know, between us. It's going to be all confidential. Just go to PRN and sign with them, and you can continue working. And many times the physician is put in a position of, it's my livelihood, and continue to work and make a living and provide for my family, or basically I'm going to get fired from my job.
That's right.
In that decision is extremely hard for my clients because we have to negotiate with the hospital or the employer at the same time that we're negotiating with the department, at the same time that we are maybe negotiating with PRN. Yeah. And the most important thing many times is your job, right? And how do you earn a living? So you get put in a position that it's not an easy position.
It's unconscionable. It's simply unconscionable. And I would say that it is the equivalent of psychological torture. I really believe that. And I believe what we're really talking about is human rights violations, not just simply civil rights violations, but human rights violations. And so I don't know whether you follow the work of Pamela Weibel and her work around physician suicide, but every year we lose the equivalent of 400, a med school class, 400 physicians a year to suicide.
Really?
Okay.
Didn't know.
Now, and a significant portion of those are caught in this unconscionable bind. And I see it as an emergency. I see it as a public health emergency affecting the physician community. And we're going to have to put our heads together to address this so that physicians' rights can be preserved. And because you're entitled to due process, you're entitled to a fair hearing, you're also entitled to a fair psychiatric evaluation. And if they're rigging the deck, okay, if they're setting up the equivalent of a kangaroo court in the medical system, this has to be confronted and it has to be halted, because to prevent somebody from having an independent evaluation is against all fundamental medical ethical tenets, underwritten by the American College of Medicine. This is just simply, it's unacceptable. And my newer understanding is that it's in violation of multiple aspects of law. And as I become more versed in ADA, ADA is basically saying, hey, look, the person has a right to choose their own evaluator. And I frankly, Juan, I don't understand how states are getting away with abrogating federal rights like this and saying, oh no, we have the right to determine who you go to, when the ADA is saying, oh no, you don't. And a physician who's regarded as disabled has certain rights that have to be honored.
I'll leave you with this because I have a meeting soon. It's so bad that these people go to a doctor and they go to one of these addiction specialists, right? Yeah. And this guy just sees the patient or sees my client for 40 minutes.
Yeah.
While those 40 minutes, he's been treated all his life with physicians, psychiatrists, psychologists, and he has a list of all his healthcare providers that he's been going to entire life.
Yeah.
He goes to this addiction specialist certified by PRN. The guy tells him you have to quit all of your medicines. If you were taking Adderall,
Gross
legally
malpractice.
prescribed,
It's gross malpractice right at the
you
outset.
have to take so basically you're putting your confidence and the board and the department and everybody
Yes.
in a doctor that just sees a patient for 40 minutes
Mhm.
and you have all these medical
Yeah.
records throughout all this medical information and data that
Yeah.
they won't even take into consideration, and
Yeah.
that doctor
Quite
goes
frankly-
over their own doctor. So
Quite frankly, again, I'm not a lawyer, but quite frankly, Juan, I think that what we have here is a malpractice case. And if PRN saying we're off the hook, it's just what the independent contractor says. Well, guess what, independent contractor? If you're operating under your medical license in that evaluation, that is gross malpractice, and they need to be brought before the board for gross malpractice and endangerment to that physician's life. And there's no doubt in my mind about that. And it has to be
100%.
pursued aggressively.
And I'll leave you with this. I
Yeah.
know for a fact what a couple of these type of providers that are certified that PRN sends our clients to.
Yeah.
I have them, clients of mine, two of them, basically one specific doctor, they narrated the same story. She comes into the office and the doctor, before evaluating her or anything, she goes like, not to worry, go to PRN or IPN, you'll be there for a year. They're already convincing her to go into the program before they even evaluate her, to the point that doctor, I think that client of mine is going to file a suit against him. That doctor was complimenting his physique and all of that. So it's pretty gross and it's pretty bad what's going on.
It is horrible. And I think also what we're dealing with, frankly, I think we're looking at a RICO, a racketeering influence criminal organization. This has all the hallmarks of that. And the worst thing is it's a state-sponsored one. It's one that's being done through exclusive contracting. And I can't wait for you and I and others to put our heads together and join collaboratively on this. Because I think what this is going to take is a collection of thinkers, of legal thinkers, of medical thinkers, of strategists, to take a look at what can we do to address this, because it's fundamentally wrong and it's destroying lives. And every physician's life who is disrupted in this way, patient care is disrupted and their families are disrupted. And the ripple effect is huge. And so I thank you for the work you're doing with this, and I look forward to continuing our dialogue.
No, we will. And it's really, I didn't know that a doctor knew so much about this process. I was in a board of nursing hearing probably a month ago that the panel voted 4-3 against me, sending my client to IPN, which is for nurses. And I felt so frustrated to the point that I'm like, listen, what's the point now? So that you basically, that you're getting into it, that you're researching the issue, it gives me light, that basically.
Well, I'm glad to hear that. Yeah, I'm glad to hear that. And I tell you what, let's gather a group of healthcare lawyers who are really interested in defending physicians' rights. And I guarantee you, we're going to make a powerhouse. We're going to make some changes here. Thank you
so
much.
Doctor.
Thanks for having me.
Thank you so much. Have a beautiful day.